If you became a U.S. citizen through naturalization, and lately you found yourself lying awake at night wondering, can they take this away from me? You are not alone. That question has been sitting quietly in the minds of many people. You see the headlines, you watch the enforcement footage, you hear words like crackdown, deportation, immigration overhaul, and suddenly something that once felt permanent begins to feel uncertain. You worked for this, you studied for the civics test, you prepared for the interview, you stood in a courtroom, raised your hand, and took the oath. In that moment, you believed it meant safety, finality, protection. So, when immigration policy dominates the news in February 2026, it's completely natural to ask yourself, has anything changed about my citizenship? Is naturalized citizenship really secure? Could enforcement policy somehow reach me? Today, we're going to separate fear from fact, headlines from law, and speculation from constitutional reality. Because there is a massive difference between a louder enforcement environment and an actual legal threat to your citizenship. And once you understand that difference clearly, everything starts to feel different. Hi, I'm June, and welcome to U.S. Immigration News. My work focuses on breaking down immigration policy in a way that is clear, calm, and grounded in facts, especially during moments like this when anxiety spreads faster than accurate information. In this video, we're going to walk carefully through what Trump immigration policy in February 2026 actually means for naturalized citizens, what the Constitution guarantees, what denaturalization really is and what it is not, and the practical steps you should or should not take right now. This isn't about politics, it's about law, rights, and clarity. By the end of this, you'll know exactly where you stand, what is protected, and what you can confidently stop worrying about. And that clarity matters more than ever. Let's begin with the foundation, because once this is clear, much of the fear starts to fall away. Under the United States Constitution, citizenship that has been lawfully granted is permanent. That isn't a political talking point. It doesn't depend on who is president. It is constitutional law supported by Supreme Court precedent going back decades. If you completed the naturalization process, met the residency requirements, passed your civics and English exams, disclosed the required information honestly, and took the oath of allegiance, you are a United States citizen with the same constitutional protections as someone born in this country. Your citizenship is not a visa. It is not a green card. It is not conditional status. It does not renew. It does not expire, and it cannot be taken away simply because immigration enforcement becomes more aggressive or political leadership shifts priorities. Executive orders cannot override constitutional protections. Changes in enforcement strategy cannot rewrite the 14th Amendment. Congress cannot pass a simple law that suddenly strips lawfully naturalized citizens of their status. Citizenship, once properly granted, is not fragile. It is one of the strongest legal statuses that exists in American law. And I want to pause here for a moment because this point is deeply important. Many people carry forward the anxiety they once felt as permanent residents into their lives as citizens. As a green card holder, your status could be questioned under certain circumstances. There were conditions, there were risks, there were renewal requirements. Make sure you're subscribed to this channel so you don't have to rely on rumors or social media threads the next time immigration dominates the headlines. Accurate information is one of the strongest forms of protection you have. Now, with that foundation in place, we need to be precise about one narrow legal exception people often hear about without fully understanding. It's called denaturalization. And just hearing that word can create panic because it sounds like the government can simply undo citizenship. That's not what it means. Denaturalization is a formal legal process that can only happen in federal court and only under very specific circumstances. The government must prove that a person obtained citizenship through fraud or by willfully concealing a material fact during the naturalization process. This is not about policy disagreements. It's not about changing political views. It's not about criticizing the government. It is about whether the original naturalization was legally valid. To meet that standard, prosecutors would need to show evidence that someone deliberately lied on their N-400 application, hid serious criminal history that would have made them ineligible, used a false identity, concealed involvement in persecution or terrorism, or omitted information that was legally material to the approval decision. And even in those situations, it is not automatic. The government must file a civil lawsuit. The individual has the right to legal representation. There is discovery. There are evidentiary standards. There is a judge. The burden of proof is high. Historically, denaturalization cases are rare, time-consuming, and expensive. They are not mass administrative actions. They are individualized federal court proceedings that often take years to resolve. This distinction is enormously important in 2026. When people hear about stronger immigration enforcement, some assume citizenship could somehow be swept into that enforcement wave. But denaturalization is not a casual policy tool. The legal standard has not changed. There has been no new law lowering the burden of proof. There has been no Supreme Court decision weakening constitutional protections for naturalized citizens. Even if an administration chose to pursue denaturalization cases more aggressively in situations involving proven fraud, would still be bound by the same constitutional requirements and due process protections that have existed for decades. So when you hear the phrase revoking citizenship, understand that in reality, it refers to a narrow court-driven process tied to fraud, not a political lever that can be pulled against law-abiding naturalized Americans. So if citizenship is constitutionally protected and denaturalization is rare and fraud-based, what exactly is happening in February 2026 that is making so many people uneasy? The answer is enforcement visibility. The current administration has significantly increased immigration enforcement operations. ICE activity is more frequent and more visible. Detention policies are stricter. Border enforcement has intensified. Deportation efforts are being prioritized for individuals who are undocumented or who have final removal orders. That increased visibility changes how communities feel, even if it does not change the legal reality for citizens. When you see workplace raids on the news, when you hear about large-scale removal operations, when social media amplifies every enforcement story, it can create the impression that the entire immigration landscape is unstable. But here is the critical distinction. Enforcement actions target immigration status violations. Naturalized citizens do not have an immigration status. You have citizenship. You are not in the category of people subject to deportation proceedings. You do not need a visa. You do not renew anything. Your legal relationship with the United States is fundamentally different from someone who is undocumented or even someone who is a permanent resident. Confusion spreads because immigration policy debates are often framed broadly. Crackdown on immigrants, strict immigration overhaul, new deportation push. Those phrases collapse multiple legal categories into one emotional headline. Crackdown on immigrants, strict immigration overhaul, new deportation push. Those phrases collapse multiple legal categories into one emotional headline. A green card holder is not the same as an undocumented immigrant. A visa holder is not the same as a naturalized citizen. Enforcement aimed at unlawful presence does not legally extend to people who have completed naturalization. And yet, when rhetoric becomes intense, people who spent years navigating a vulnerable immigration system can instinctively feel that vulnerability returning. But tone is not law. Visibility is not a constitutional amendment. And intensity does not rewrite citizenship protections. Let's address 3 common claims circulating right now because misinformation spreads quickly in environments like this. The first claim is that mass denaturalization is coming, that the government is preparing to strip citizenship from large numbers of naturalized Americans. There is no legal mechanism for this. There is no new legislation authorizing it. There has been no constitutional change allowing it. Denaturalization requires individualized federal court proceedings tied to fraud. It cannot be executed in bulk through administrative action. The second claim is that certain nationalities or religious groups are being targeted for citizenship revocation. While enforcement priorities can focus on particular geographic regions or security concerns, denaturalization must be based on fraud or material misrepresentation, not race, religion. The first claim is that mass denaturalization is coming, that the government is preparing to strip citizenship from large numbers of naturalized Americans. There is no legal mechanism for this. There is no new legislation authorizing it. There has been no constitutional change allowing it. Denaturalization requires individualized federal court proceedings tied to fraud. It cannot be executed in bulk through administrative action. The second claim is that certain nationalities or religious groups are being targeted for citizenship revocation. While enforcement priorities can focus on particular geographic regions or security concerns, denaturalization must be based on fraud or material misrepresentation, not race, religion, ethnicity, or political belief. Targeting citizenship revocation based on those characteristics would be unconstitutional and immediately challenged in federal court. The third claim is that naturalized citizens need to take urgent, dramatic steps to protect their citizenship. Renouncing prior citizenship immediately, filing special paperwork, paying for protection services, or registering with organizations promising safeguards. None of that is necessary. Your citizenship is protected by the Constitution, not by additional filings or private services. Fear-based businesses often emerge during uncertain times. Be cautious of anyone asking you to pay money to secure something that is already legally secure. When you separate enforcement optics from legal authority, the picture becomes clearer and far less frightening. Now, let's move into something practical. Not because your citizenship is in danger, but because clarity becomes even more powerful when paired with preparation. First, safeguard your documentation. Keep your naturalization certificate in a secure location. Make physical copies if possible. Create secure digital scans. This is not because someone is coming to question your citizenship randomly. It is because having easy access to proof eliminates stress if you ever need to apply for a passport, sponsor a family member, replace documents, or verify your status. Organization reduces anxiety. Second, understand your rights. As a citizen, you have full constitutional protections. You have the right to due process. You cannot be deported. You can travel on a U.S. passport. You can vote. You can petition for family members. These rights are enforceable. Sometimes simply reviewing what citizenship grants you restores stability that headlines can temporarily shake. Third, if you have family members who are lawful permanent residents and eligible for naturalization, this may be a meaningful moment to encourage them to apply. Permanent residence is strong, but it is not the same as citizenship. If this breakdown is helping you think more clearly about your situation or your family's options, consider sharing this video with someone who may be quietly worried but hasn't asked these questions out loud. Clarity often spreads one conversation at a time. For more complex family scenarios, anxiety often runs deeper. If you have undocumented relatives, the current enforcement environment is active and real. Deportations are occurring. Undocumented status carries vulnerability. That does not mean panic, but it does mean consultation. There may be pathways that haven't been explored. Adjustment through family, humanitarian protections, waivers, cancellation of removal depending on the specific facts, but those options are individualized and require evaluation by a licensed immigration attorney. If you are sponsoring a relative abroad, understand that family-based immigration remains legal, but processing times may lengthen, scrutiny may increase, and policy adjustments can affect categories. If you travel internationally as a naturalized citizen, always travel on your U.S. passport. The United States recognizes dual citizenship, but some countries do not. Be aware of the laws of your country of origin regarding dual nationality or other obligations. At this point, you may wonder whether you need an immigration attorney right now. For most naturalized citizens with straightforward histories, the answer is no. If you obtained citizenship lawfully, disclosed information honestly, and have not received any government communication regarding fraud or misrepresentation, there is no preventive filing you need to make. Citizenship does not require maintenance or renewal. However, if you are sponsoring family members with complex histories, if undocumented relatives are assessing options, or if you ever receive formal communication from USCIS or the Department of Justice questioning past immigration representations, that is when you seek counsel immediately. And when you do, choose a licensed immigration attorney, ideally one connected to reputable organizations like the American Immigration Lawyers Association. Be cautious of anyone who guarantees outcomes or demands large cash payments without written agreements. Legal guidance should reduce anxiety, not exploit it. Finally, let's acknowledge something that doesn't appear in statutes or court rulings, but is very real. Emotional residue. Many naturalized citizens carry years of immigration-related stress. You remember checking case statuses obsessively, worrying about documents, fearing a mistake could derail everything. That imprint does not disappear overnight. So when enforcement headlines surge, even if your logical mind knows your citizenship is secure, your nervous system may react differently. That does not mean you misunderstand the law. It means you lived through uncertainty. You navigated a complex system. You earned your citizenship lawfully. Political climate can shift quickly. Enforcement priorities can intensify. Media coverage can amplify, but constitutional structure moves slowly and deliberately. Citizenship is anchored in the 14th Amendment and reinforced by decades of Supreme Court precedent. That foundation does not move with election cycles. So, here is what we know clearly in February 2026. Immigration enforcement is visible and active. Deportations of undocumented individuals are occurring. Border and detention policies have tightened. Policy debates continue. But none of those developments alter the permanence of lawfully obtained naturalized citizenship. If you answered your application truthfully, met eligibility requirements, and took the oath, your citizenship is secure under the Constitution. That is not optimism. It is legal fact. The path forward is not panic. It is awareness. Stay informed through reliable sources. Keep your documents organized. Encourage eligible family members to naturalize. Seek professional advice when cases are complex. And most importantly, allow yourself to live in the stability you earned. You have the right to vote. You have the right to hold a U.S. passport. You have the right to petition for family members. You have the right to live here without fear of deportation. These are not symbolic rights.